Fabulous. Thank you, everyone. It's a pleasure to be here with you. I'm now going to attempt to share a screen, so please bear with me. Share screen, this button, then this button, and there is the screen for us. I hope, soon. Participants can now see my screen, so hopefully you see a nice graphic. Thank you very much for having us here today. It is the last session for an excellent conference, an absolute credit to our President Glenn, General Secretary Anselm, the organising committee, and our generous sponsors at the Barcelona Law Association. I'm especially glad to be here in my capacity as President of the Australian Society for Computers and the Law, a proud member association of IFCLA. As you would all know, IFCLA represents national technology law associations from across the globe. And if you can see my screen, you can see a number of those flags on the screen. We represent Australia and New Zealand and have plans to grow strongly within our region. If you belong to an organisation that is not yet a member of IFCLA, I encourage you, of course, to join. Today, I join you from Sydney, the lands of the Gadigal people of the Eora Nation, and pay our respect to their elders past and present, and all First Nations people joining us here today. In this session, we'll be exploring cybersecurity with a cross-disciplinary panel from Sydney, Toronto, and New York. It feels like we have the world covered. Professor Richard Buckland, Jenna Karabil, and John Beardwood join us tonight, or morning, depending where you are. Cybercrime, of course, is a broad term and can encompass many types of crime. Cyber-dependent crimes, or attacks on machines, if you like, such as malware or distributed denial of service attacks, sometimes referred to as pure cyber crimes. Always one category, sometimes referred to as pure cyber crimes. Another category are those that are basically traditional crimes, but just enabled by computers or machines, such as identity fraud and identity theft and fraud. Now, the reason why I make this distinction, not because we'll necessarily carry it through to the panel, but because the Australian Institute of Criminology looked at that first pure cybercrime category and estimated that the cost for Australia alone in 2019 cost around $3.5 billion. And $2 billion of that was estimated to have come directly out of the pockets of victims. So many have attempted to estimate the total cost of cybercrime internationally, and I'm sure our panelists may offer, other numbers, and we're happy to have a discussion even just around the numbers and how we need to have good metrics to understand the exposure. But CISN has estimated that in 2020 it was $10.5 trillion on that first category of pure cyber crimes. And that's estimated to increase by at least 15% every year. Really keen to hear from our panelists on whether they think that's completely underrepresented or, just about right. So cybercrime, no matter how you slice and dice it, no matter how you define it, it is certainly a growing, borderless, and a continually evolving body of crimes which threaten individuals, businesses, governments, and national security. Today, we will be exploring the latest trends, techniques. We will be looking at a recent survey of our industry, best practice, countermeasures, contractual and insurance issues, all in the 1.5 hours allocated. Each speaker will present for 15 minutes or so each. And that would leave therefore ample time for us to have an interactive Q&A session, which being the last session for the conference, we want to make particularly interactive. So please post your questions in Q&A. That's at the bottom of your screen, Q&A, and we'll look forward to engaging with your questions and with the panelists. So first to present is Professor Richard Buckland. Richard, if I may, is Professor of Cybersecurity, Cybercrime, Cyber Law, and I like to say cyber everything at the University of New South Wales here in Sydney. He has served on numerous education and cybersecurity boards of professional bodies, corporations, and educational institutions, both here and internationally. He is Director of SecEDU, the Australian Cybersecurity Capability Network, and member of our Society's National Advisory Board. Over 2 decades, he has trained tens of thousands of remarkable students, and many of those now hold senior cybersecurity roles in leading organisations across the world. So, Richard, you probably didn't want me to mention this, but you have received multiple awards for your exceptional contribution to education and the field of cybersecurity, for which we thank you very much. Richard, now over to you to highlight a number of the techniques used by cyber criminals and the trends that you see emerging. Thank you, Richard, and thank you for joining us so late at night and into the early morning for such an exciting topic. Thank you, Richard. Over to you. And I'll stop sharing my screen and you may be on mute.
Thank you, Marina, and hello, everyone. It's an honour and a privilege to be here. I'm in Sydney, as Marina mentioned. It's the middle of the night for us here. And after discussions with Marina and the panelists, what I'd really like to do in this first of the 3 talks is talk about the trends. I assume you're all familiar with cybersecurity in some way or another, and I assume most people in the room are lawyers. Marina, is that a reasonable assumption?
Yes.
Yes, thank you, she's nodding. So you probably know a bit about now. I thought I'd give you a security engineer's take on what happens next, what the future is going to look like. So in Sydney, we have the lovely Sydney Harbour Bridge, and I was driving across it the other day thinking of my daughter's birthday. And it turns out that's a remarkable thing. In fact, that's an astonishing thing. Because, not because of what I was thinking, but because of what I wasn't thinking about. I wasn't anxiously looking over the side of the car for cracks. I wasn't checking if the bridge was swaying. I wasn't checking if other cars were heading towards me. I wasn't worried in any sense or any way that I was imperiled or that I was going to die. I just assumed the bridge was absolutely fine and safe and secure. And it was appropriate for my mind almost to be elsewhere as I was driving across it. And that's thanks to engineering. I've traveled to various places around the world. And I do remember when I was very young in Nepal, traveling across a bridge, a rope bridge, and I certainly wasn't thinking of anyone's birthday. I was holding on tight, wishing wishing I hadn't come, and at every step worried that the bridge would collapse. Now, and it didn't. So what is this miracle that frees our minds up and lets us think of other things? I would claim a lot of the safety of the bridge comes from the engineering processes that have gone in to build it. Early bridges would fall down. Bridges we build today, certified by engineers, tend not to fall down. And that's such a miracle, but it's a commonplace miracle that we don't even notice. And why am I talking about it? Because we haven't achieved that with computer security. We don't know how to build a bridge that doesn't fall down. We don't yet know, and by we, I mean everyone, including highly funded groups like the NSA or Microsoft or Google. No one knows how to build a secure computer, and no one knows how to write secure code to run on a secure computer. And there is no computer you can be driving across happily thinking about your daughter's birthday and not worrying about being attacked. And so I wonder if that's going to stay like that, or that's just a situation we're in now. And I'm going to talk about that a little bit. So first of all, let me tell you the sort of structural factors that we consider when we look at the situation we're in now and when we think about where we're going in the future. And to do that, I'd like to give you an example. When I teach cybersecurity students, the very first lesson I give them is I take them down to a foyer near the lecture theatre, and I ask them, and it's at nighttime, and I ask them to look at the theatre from the outside, the foyer from the outside, and in pairs, identify all the physical security features that are used to make that foyer secure, that would stop someone being able to break into the foyer. And I give them about 10 minutes to do it. And by the end, everyone has an impressive list of physical security features, subtle ones and obvious ones, that make it very difficult to get access to that foyer if you don't have legitimate access, if you haven't been granted access. And then I ask everyone to indicate on a scale of 1 to 5 how secure they think it is. And invariably everyone says 4 or 5, you know, as secure as it can be. And I say, thank you very much, everyone. You've done a wonderful job, great analysis. We're going to have a break now, 5 minutes. And the first person to break into that foyer without breaking any laws, without using anything special, without using any technology, without doing anything wrong, without damaging anything, and only using things they have in their pockets or lying around on the ground, the first person to break in gets a Mars bar. And every year someone gets in within 3 minutes. Now, this is a place that a few minutes ago they were thinking was highly secure. And the whole point of this class is I'm trying to get students to understand the difference between the defender mindset and the attacker mindset. When we're a defender and we're looking at something that we think is secure, we look at the most secure components and we congratulate ourselves at how secure they are. And I sort of tricked and primed them by getting them to think about what the good physical features were. They were focused entirely on the good features. And of course, attackers don't care about that at all. Attackers ignore the good features and attack the weak features. I don't know if you can build a building that can't be broken into, but it's very, very hard. But I know a building is far easier to protect than a computer. And the main thing we have to do as security engineers is break the habit of thinking like a defender, having the defender mindset. We have to understand the attacker mindset, which is looking for weakness and probing. Now, the common way that attackers get into systems nowadays, the technical exploits that they use, tend to be based around a class of what we call vulnerabilities. They're bugs in the software that can be exploited by the bad guys to get access. We tend to care about, or attackers tend to use mainly vulnerabilities based around something called memory corruption. And the very early attacks like Stack Overflow attacks, but also a whole lot of attacks since then are based around this idea of essentially corrupting the memory in a way to force the computer, which thinks it's obeying the laws legitimately and following the computer legitimately, to essentially trick it into doing what we want it to do, not what the authors intended it to do. Now, Intel researchers, really smart researchers, cryptographers, a whole lot of people around the world have been working on trying to stamp out memory corruption vulnerabilities. And they've made enormous progress, and whole classes that used to exist no longer work. So is it possible, for example, that in the future, we may get to a state where memory corruption vulnerabilities essentially don't exist anymore? And the answer to that is, yeah, it is possible. It is possible that we'll be able to do that. Does that then mean that systems will be secure and we can drive across the bridge and be free to think of birthday parties? And the answer is no, unfortunately. And the reason for that is, in fact, really simple. If you think of legislation or laws, my daughter is studying law, and she had a scenario, and she said, I have to work out if this is okay or not. I have to persuade a judge whether this situation was legal or not. And I said, well, what's the right answer? Do you know? And she said, Dad, you're completely misunderstanding the law. There's no way of knowing the right answer. It's too complex. There's too many laws here. So I'll look through this legislation all night and tomorrow, looking for as many arguments as I can that it's okay. And the other side will look through the legislation, looking for as many arguments as they can that it's not okay. And it'll be very, very complex, and it's very hard to weigh up. And we won't even know going into the court case whether we'll win or not. And I said, that doesn't seem right. You mean citizens can do things and not even know whether those things are legal or not? And she just laughed and looked at me like I'm an idiot. And I'm sure you're doing the same, because the law is very complex, she was explaining. Now, if you took all the legislation of your country, and you guys all got together and put it all together. So if we got all the legislation of all the countries in the world and put it all together, that's a very, very complex thing. Even looking at Australia's tax legislation, which is so complex that people are always able to get around it and do tax evasion. Even looking at that, that's a huge pile, but that's only a fraction of Australia's legislation. If we added all your legislation to our legislation, what an enormous pile of legislation that would be. Now, all the rules and all the complexity implicit in all of that legislation is an order of magnitude less than the complexity of the software sitting on your phone at the moment. What we've done with computers is we've built really smart, fast devices that are able to do large amounts of things really quickly. And then to compensate for that, we've then given them ridiculously large amounts of highly complex things to do, so they can just do them in normal time. And this means that the systems we build are so complex that no single person can understand them. And you, being lawyers, probably understand that better than anyone, perhaps, except computer programmers, that with complexity comes error. And with error comes vulnerability. Computer programmers know this, and you'll know if you've ever written any code. If you were a room of programmers, what I would ask you now is, put up your hand if you've written software that doesn't contain an error. We call them bugs because it's less offensive to say to yourself, oh, my software has a bug, rather than to say to yourself, my software is flawed, has a terrible mistake, and I'm a hopeless programmer. So put up your hand if you've ever written software that doesn't have a bug in it. And then we'd all laugh. No one would put their hand up and we'd all laugh because we know that's a ridiculous question. All the software we write has bugs in it, even the simplest programs. There's a famous computer scientist who used to analyze, I think he was at Princeton. He had analyzed one of the very simplest algorithms you can write, which is called binary search. And he looked at all the textbooks that had binary searches as model solutions for students in. And in his software class, Programming Pearls, it was called, John Bentley, he would then one by one go through all these textbooks and show the students how every implementation in the textbook had a mistake in it, a bug. And they would all laugh and laugh and laugh. And they would spend the rest of the term trying to write a perfect version of this software that didn't have a bug. And he knew what that was, and eventually they'd get it. And he published the perfect version in his book. And years later, you can probably guess what I'm going to say, someone else analyzing that found a bug in it. It took less than a page. It wasn't an encyclopedia full of code that was complexity. It was enough you could write it on a Post-it note. And yet the small amount of code there was enough to contain an error. So with all the code we have and all the complexity, there is no way that a single person can comprehend or understand it all. And with no way that a single person can comprehend or understand it all, there's no way we can allow for unexpected interactions and unexpected side effects. And it's the interactions actually that kill us. The number of interactions between software components increases as the square of the number of components. So if you have 100 times more components, you have 10,000 times more interactions. And each one of those interactions is a possibility for code. So an error. So as software gets more and more complex, code gets more and more complex. And I like to say that our reach does not exceed, it does not match our grasp. And somehow, as humans, we always yearn for more than we can have. And as computers get better and faster and smarter, well, chips get more powerful, then instead of sitting back happily and saying, now we can write secure code, we just write more and more complex code that can do more and more elaborate things. And I think that's the human nature. We will always be doing that. So I know of no way that we will ever be able to write code that we can assure is safe. We have a saying, which is, you will be hacked. We all know we'll be hacked. The NSA, who has orders of magnitude more money than everyone, and smarts, has been hacked. Google is hacked regularly. And they are very good and very smart, and have lots of my former students there. And but in spite of that, they're still hacked, not because of that. So the question is not, can we make something secure? The answer to that is really obvious, and we never will be able to. We have a saying that if you want to make your computer secure, the only way we know of doing it is to unplug it, to smash it with a hammer, to dig a hole in the ground, put it in the hole, to pour concrete in the hole, and then to jump up and down on top of the concrete. And then perhaps it's secure. So the question for us and for you, for us as citizens, and perhaps for you as lawyers is, okay, then what does that give us? What world are we in now where computers will never be secure? Perfectly secure. Because that's where we want to live. If life was a Hollywood movie, we'd like a really easy, simple solution. Unfortunately, it's not that. The computers we have will always have problems, and attackers will always be able to circumvent any security system anyone builds ever, depending on their resources and time and how lucky you are. So what does that mean? What are the implications for society, civil society? Because if we think about it, I guess inexorably since 1980, we've gradually moved more and more of our lives and more of our society, more and more of our world out of the physical world into the digital world. And we now have elections in the digital world. Our assets and resources are stored in the digital world. Our bank accounts, our traffic lights are controlled, our aeroplanes are controlled, our radar systems are controlled, our communications, our reflections, our thoughts, our photos, our dreams. Now, if you think of social media, are all there. Our memories in many ways. I certainly outsource a lot of my memories now to devices, but also turning on and off the lights, turning on and off nuclear power stations, opening dams, running power grids, monitoring flows, policing, everything you can, launching nuclear missiles, controlling planes, eventually controlling cars. All of these things now live in the digital world. So in the physical world, we've discovered, I think, as societies evolve, that there are always bad guys who will always try and do bad things. And we've needed laws and police and a whole lot of mechanisms to deal with that. As we move into the digital world, we'll need the same things. And yet it's so new, we haven't really got good traditions or habits there, and our intuitions from the physical world won't necessarily help us. So this is a big legal challenge. So I guess today, I'm hoping you'll ask lots of questions about this later on. Today, we'll be talking about the state we're in now and what firms can do. And I just would really hope that everyone leaves this session in the mindset of realizing this is a difficult problem that has no perfect solution. So that's not depressing, that's sort of exciting. It means the onus is on us now to work out strategies and ways of mitigating, of controlling risk and understanding risk, of making sensible decisions, of making good trade-offs, of considering things like insurance, considering things like legislation and reform, perhaps even considering regulation. And I know that's a dirty word for lots of you in various countries you come from. You might come from low regulation countries, but I bet no matter how light touch the government is in your country, no matter how little regulation you have in your country, I still bet that civil engineers are regulated. And I still bet that no one's allowed to throw up a bridge over a river without getting it certified by an engineer and things signed off. And I bet that's embedded in legislation. And the role of an engineer and how we know if people are suitably qualified as an engineers and all of that. And no one grumbles about that because that makes sense. Marina mentioned the cost of cybercrime currently is 10 trillion. I mean, that's at the upper end, to be honest, of estimates. And the estimates that I know of range from about 1 to 10. And notice that's from about 1 to 10% of global GDP. This is only increasing. So that's bigger than the cost of all drug-related crime, plus all drug-related misuse, plus cigarette crime, damage, internal, short-term and long-term, plus drinking. All of those, it's the same order, but it's this huge problem. We focus so much attention and we're so familiar with the drug side. Eventually we will with the cyber side, but at the moment it's all new territory. So anyway, lots of exciting thoughts. I have some funny anecdotes that I've spoken for too long and I won't give you, but hopefully you can ask me questions. Thank you very much, everyone. Lovely to be.
Fabulous, Richard. Take up Richard's offer of putting questions in Q&A. Richard, something I'd like you to think about in time for our Q&A session. Throughout the conference, we've heard about blockchain, IoT, smart cities, quantum. Could you please pick an area of emerging technology and how cyber relates to it, and maybe even some case studies of, sort of the famous attacks and how they got into the system?
Sure.
You know, a vulnerable wheel of a Tesla car, for example. You know, how is this done? Give us some insight, please, into how that white hat or that black hat person goes about doing what they do. Of course, attacker mindset, but some juicy examples would be wonderful. Okay, so our next speaker today to explore the impact and perceptions of our industry on cyber will be presented by John Beardwood. John is a senior partner of Fasken LLP, a leading Canadian law firm. He is past chair of the firm's technology practice and co-founder of the privacy information outsourcing practice groups within the firm also. Those practice areas include cybersecurity law. He is past president of iTech Law, has served on the IFCLA board for several years, particularly while he was representative of the Canadian Technology Law Association, of which he was co-founder. John's expertise and contribution has also been recognised by several awards. This year, John was recognised as one of 4 global elite thought leaders in America from the Who's Who Legal in IT and Privacy. John, what a fabulous title, Global Elite Thought Leader. We're very fortunate to have you here today. Thank you for taking us through the results of the second cyber survey. Please also let us know how you were involved in that survey so we can do justice to your contribution. Thank you, John, and over to you.
Thank you. Thank you, Richard, for the great opening remarks. In order to talk about the roots of the survey, it's impossible to do that without talking about the Ashley Madison privacy breach, which happened back in 2015 and resulted in a joint report being issued by the Australian Privacy Commissioner and by the Canadian Privacy Commissioner. And the reason why that report was so absolutely critical for lawyers in this area is because the standard, and this is pretty universal amongst many jurisdictions, the standard for security measures, in other words, the legal standard that organizations were required to comply with, was simply reasonable and appropriate security. So if your client comes up to you and asks you what reasonable appropriate security looks like, very likely you're not going to have a very good sense, because that's a very amorphous standard and it changes from day to day. So the reason why this report was incredibly important is, for the first time, and I should say this reasonable appropriate standard is very similar in the UK and other Western, even in the United States. The reason why this report was so important is that it actually went through in detail what the expectations of the privacy commissioners were with respect to security. And when I say in detail, I mean in detail. What they basically did is did a checklist in terms of what the company, in the case of the Ashley Madison privacy breach, the company's name is Avid, what security Ashley Madison had in place, and what security they did not have in place. Now, this happened about 5 years ago, so many of you will not remember, but in a nutshell, Ashley Madison was basically a dating site for people who wanted to have affairs. So as you can imagine, the personal information they were collecting was highly, highly sensitive. And in fact, in connection with the investigation, it became very apparent that as a result of the breach, some people were actually being extorted. So we're talking about very, very sensitive information here, which is likely why we had both commissioners sort of doing a joint report together. Now, Avid, who is running Ashley Madison, amongst a number of other dating sites, Avid did not have a light touch with respect to security. I'm going to ask you to indulge me for 2 seconds while I list off exactly what they already did. And the reason why this is important is because the commissioners turned around and said that isn't enough. So they had physical safeguards. They had servers that were stored in an isolated locked room with limited access. They had production servers in a cage requiring a biometric scan, an access card, a photo ID, and a combination lock code. They had multiple network protections, including network segmentation, firewalls, and encryptions on all web communications. All external access to the network was logged. All network access was via VPN, which required authorization on a per user basis. They had antivirus software. For very sensitive information, it was encrypted and internal access was very limited. Passwords were hashed. They had organizational safeguards. They had commenced staff training on a general privacy and security course a few months before the incident. They had engaged the director of information security and had instituted in 2015 a bug bounty program. For those of you who are familiar with what that is, you basically pay people to see if they can find bugs in your software. They had a long list of security safeguards in place. And both privacy commissioners turned around and said that was absolutely not enough. And because both the commissioners spent the time to say what you should have is an actual a program which has 4 key steps, 4 key elements, we took those elements and shaped the questions for the cybersecurity survey when we first held it a number of years ago. And we just finished doing the other one, the new one, the second one in the last couple of weeks. So that Ashley Madison report is what inspired us to circulate this cybersecurity survey to the CIOs and CTOs of our clients. And the advantage of having done 2 is that we now can understand what the trends are. So I'm going to talk a little bit about what we found, and then we can go into more detail. So, I should say that as a result of the survey, we generated a full report, and for those who participated, because I will tell you that it's very difficult to get organizations to comply or rather to complete security questionnaires, even though of course the results are anonymous. Nobody really wants to talk about their dirty laundry, and there's always, of course, always a sensitivity that if they go into too much detail about their current security measures, then hackers will duly take note and try to penetrate them. So it's always difficult to get a huge base of respondents. Okay, so the 4 principles you'll see in the slide here, the 4 principles that the privacy commissioner set out in their very, very detailed report, which I suggest you would read if you have an interest in this area, is a 4-step program for you to assess your security requirements. First of all is to understand your data. What data do you have and how sensitive is it? So it's effectively doing internal due diligence with respect to the data you hold. Second step is risk assessment. So for each data set, you should assess what the security risks are with respect to that data set. Third, you should assess what safeguards you need to address those particular security risks. And fourth, we should adopt ongoing policies and procedures to make sure that those safeguards are continuously updated, including, but not without limiting that, to using external security consultants to sort of give you the latest and greatest advice in terms of what your security measures should be. And Ashley Madison, Avid being the owner again, had a number of the, which I will call security gigas. They had the firewalls, they had a segmented network, they had antivirus software. But what they didn't have, and as we'll discuss, is they didn't have a documented program with these 4 steps that they could show to the commissioners and say, we get it. It's not just like this year we're going to institute a firewall or upgrade our firewall. We have a full 4-step program whereby we assess the specific risks on an annual basis, and then we make sure the safeguards we have are commensurate with those risks. So when we did a comparison of our findings of this cybersecurity survey against the prior cybersecurity survey, they're very interesting because there have been significant improvements in terms of or our clients' understanding of what's required in order to meet this reasonable and appropriate security standard, as it has been supplemented by the Privacy Commissioner's report. So, and just to close off on this particular piece, although AVID did have this long list of security measures, which I just ran through, they didn't have that adequate and coherent framework. They didn't have documented information security policies and practices. So they may have been doing things, but they didn't document it. They didn't have an explicit risk management process, again, documented. So although they may have informally been assessing risks and applying security measures to those risks, they didn't document it again. And they hadn't engaged in adequate training to ensure that all staff were properly trained, which is also a major problem. So those were 3 major failings with respect to Ashley Madison, notwithstanding the very long list of security measures they had actually had in place. So the survey, I'm not going to spend a lot of time on these. This basically shows that we had a number of respondents from various different sectors. So there's a broad range of industries: healthcare, financial, on the service system implementation, service side, et cetera, et cetera. There were some small cap companies and startups. There's mostly Canadian companies that were involved in the survey. We have a vision of expanding it more internationally. So here's the key, though: findings and priorities, of which there's about 10. So this is fascinating. So if you look, the red line in each bar graph represents 2021, and the black line represents the data of original survey in 2017. You will see that security went from being a key priority for 60 and only a mid-level priority for a third, so 36% in 2017 had a mid-level, 60% had it a key priority back in 2017. Now almost 90% of the respondents would put security, information security, as being the key priority for their organization. And that is a significant difference, which has happened between 2017 and now. Now, everybody can talk the talk about it being a key priority, but of course the devil is in the details. When I talked about the 4 steps that the privacy commissioners acknowledged were key in terms of making sure you have an appropriate security program. First one, you may recall, was data assessment. 80% of the organizations who responded did review their information assets. What are they? How many do we have? Where are they located? And how critical are they to the organization and its business? 90% of the organizations review the sensitivity of their information. These are big numbers. So that's very impressive. The next step is risk assessment. So once you understand what data the company holds, then you have to understand the risks that relate to that data. 3/4 of the organizations which were surveyed actually conducted regular risk assessments of their systems. Note the word documented, because one of the lessons we'll take out of this presentation is document, document, document. They conducted regular and documented risk assessments of their systems. This increased to 75% from 42% in 2017. So clarity is clearly far more of a priority now for organizations. The third step, you will recall, is safeguard adoption. So 80% of the respondents now are conducting meaningful assessments of the actual safeguards they're putting in place to protect that data. And 80% again are now adopting clear and appropriate policies and procedures so they actually document the measures that they're putting in place. Again, document, 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 incredibly important. So you may recall that the risk management step. So it's important, you can't just set out your security program for 2021 and then let it sit there for 5 years. You're supposed to be updating it very regularly. And so we asked that question of the respondents. So how often did they update their review of their security safeguards? So you'll see we have one-time internal review audit at the top, one-time engagement of an audit by external resources. Then there's periodic engagement of external resources, review of industry material, so to keep up to speed, peer-to-peer consultation, so CIOs speaking with each other in various different fora, and or having periodic internal reviews or audits. By far, and this is a bit more troubling, 80%, recall the red line is 2021, 80% are relying on periodic internal reviews and audits. One of the things the commissioners emphasized in the report was how critically important it was to have external resources engaged to provide that third-party independent look at your security measures. That comes with a cost and it comes with effort. And unfortunately, you'll note that periodic engagement of an audit by external resources is only a third, 80% is still just doing an internal audit, which is not sufficient, and very much it is worthwhile to get a third-party consultant to provide an opinion in terms of whether you really are up to industry standards in terms of security measures. Physical safeguards. The top three options now are asset and inventory tracking, so understanding where your data is and tracking it. On-site security is 73%, and asset surveillance 64%. Now this is interesting. So having a clear desk policy, which is fairly self-explanatory, making sure that people lock up the important files away, being sure that the desk is clean, that's clear desk policy, went up from 15% in 2017 to 55% in the 2021 survey. That's a pretty low maintenance way of one particular physical safeguard. Now, in 2017, with respect to technological safeguards, we had two areas of concerns in particular. Hard to believe, but more than a third of the organizations didn't use any antivirus or malware software, which is remarkable. And also, they did not authorize remote access only on a per user basis. So in English, basically they had one system for remote access and applied to everybody sort of equally, as opposed to doing it on a per user access basis, which is extremely poor security practice. There is a significant increase in that in 2021. It went from 67% to 82%. But again, still, 1/3 of organizations continue to not authorize remote access only on a per user basis. So clearly there's room for improvement there. I mean, that's a fairly long period of time which has lapsed, and they still haven't learned that lesson. On technological safeguards to continue, in 2017, by far, firewalls are the most commonly used safeguard. Now we've got a much more diverse selection of choices, using two-factor authentication for controlling remote access. That's now at 90%. That was one of the key observations the commissioners made in the report about AVID and Ashley Madison, is the importance of multi-factor authentication. And clearly that lesson has been heard, and the majority of organizations by far are using that to control remote access. Network segmentation is equally as important, a high percentage of 81. Password protected systems and servers, 81. And consistently updating your virus definitions and running virus scans is also very high in the 81%. So much more diverse series of security measures which are being adopted now. And I think part of it is also knowledge. So not everything can be protected with just a firewall. And finally, with respect to organizational safeguards, there was a dramatic lack of organizational safeguards. And that was one of the key lessons again that came out of the Ashley Madison report, is the importance of having written information security policies. Again, remember, document, document, document. Now, over 90% have written information security policies. In 2017, it was only 56%. So that lesson has been learned. There's no point in having a wonderful security process if you don't pay for it, then you have nothing to show. Also, over 80% of the organizations have an adequate and coherent security governance framework. They have a data deletion policy, and they have a security information and security event management system. Now, training was, you may recall again with the Ashley-Madison piece, was a real problem, inadequate training. There is now a much better response rate with respect to training. So looking at the very bottom of this bar graph, you'll see that in 2017, they had formal security training for employees. Only 43% of the organizations had that. Now it's almost 3/4 at 72%. And that's pretty basic. There's no point in having state-of-the-art security measures if you don't train your employees, because as many security experts would tell you, one of the main vectors for breaching into an organization's security system is the employees. They're the weak spot. It's the employee that walks out in the parking lot, picks up a USB key, says, "Isn't this cool?" and then plugs it into his laptop. That's the vector. So training is critically important, and organizations are now hearing that. What about refreshing training? That's about the middle of the bar graph. Before it was only 1/3, now it's at almost 2/3. And you'll note also that the responses with respect to understanding the security practices of their contractors, that's the first and fourth bar graphs, has gone up significantly as well. Still low, 45% auditing of your organization subcontractors is still pretty low. Some of that can be very problematic depending on what your subcontractors' policies are with respect to allowing you to audit them. But 45% is still pretty low, but far better than what it was. 2017 was 18%. Data breach prevention. Interestingly enough, I don't think this is a particularly interesting finding. I mean, 2017, 1/3 of all organizations indicated that they have been involved in at least one data breach. Now it's 27%. Is that statistically significant? Probably not. It would be nice if it was less than that. But it still means we have approximately 1/3 of the organizations are being involved in data breaches. More organizations have now acknowledged the importance of having a designated security officer instead of throwing it under just a CTO role or sometimes an HR role. And the importance of engaging external information security consultants has gone up from 8% to 33%, but still it should be much higher. It's not to be shilling for third-party consultants, but in terms of information security, it's really good to hire the experts. Now, in terms of what about the future, one of the questions we asked was, what would make you change? Like, what would make you improve your security practices more? So last time, in 2017, 22% said, well, we're already making changes, they're in progress. So we're doing things, we're getting started. 40% of them now this time are saying that we are actively implementing additional security measures. Funding has gone up as being a concern. Only 13% in 2017 said that was a major factor. I think with the additional interest, the additional media coverage, the fact that boards of directors now being sued by their shareholders for allowing security privacy breaches to take place, more interest, more public interest means more funding. 30% of the respondents are saying that if we could get more funding, we'd be able to adopt more of these measures. Responding to customer demand, so having major clients like a bank saying you need to do this, still is relatively low. And it was 13% in 2017. It's gone down a little bit for 2021. Better knowledge of the benefits of making the improvements pretty much stayed the same. And finally, with respect to what about your competitors, and what if there was an information security dispute involving your organization, would that make a difference? No, didn't make a difference. So most of the responses had to do with, well, we are making changes right now, and funding. If we got more funding, we'd be able to get more security. And of course, that's always the challenge. Before this call, we're getting prepared. Richard and I were speaking about this with the rest of the panel. And of course, as an engineer, Richard was pointing out that, as we all know, You can have bleeding edge technology, but how much do you want to spend? These are all choices which actually have a budgetary impact. Finally, the most important policies, in other words, how do the respondents perceive the policies as being, which ones were the most important? Privacy policy is at 70%. It was at 60. It's gone up even more. Crisis management policy to deal with things like privacy breaches has gone up from 43% to 60%, so still pretty high. So these continue to be the major concerns, the major policies for the organization. There are a bunch, I won't go through all these because time does not permit, but for those who have an interest in the specific detailed security measures and how the response was in terms of which ones they actually used, those statistics are there for you. My one observation would be that you'll notice that the 2021 statistics in terms of percentages are far higher than the 2017 rather measures as they were identified in the survey. So finally, key takeaways. And I'm going to take the risk of somewhat belaboring the point, but I think it's a good one. It doesn't matter if you have a grocery list of things like we keep our doors locked, we have our servers in a cage, we have antivirus software, we have a firewall, we have a clean desk policy. That's not what is going to persuade the commissioners that you actually understood your security obligations. They get persuaded if you actually have a full program. So you may have little pieces all over the organization, but they want to understand from you that you as an organization had those pieces plug into your overall security program, your overall security methodology, which again is understand the data you have, how sensitive it is it, a risk assessment, what are the security risks with respect to each of those, so we can make sure that the security measures, the safeguards are proportionate with those risks, adopt the appropriate safeguards to make sure that they're commensurate with the risks of breaching that data. And finally, making sure you paper everything by having policies and procedures that document this is what you're doing now, and on an annual basis, this is what we're doing on an ongoing basis to make sure that these security measures are up to date and remain current state. That's what is going to persuade the regulator that your organization truly did understand what its legal obligations were and had a program in place to address those. So to close, the three words which are most important, as I said before, are document, document, document. Have the policies, have the procedures, engage in a third party a consultant to vet everything, and make sure that you have that all papered, so when the regulator drops on your doorstep, you have all the paper there to say, we get it. We looked at what you said in your various reports. We understood it. We implemented the right processes, and we papered it. And finally, on an ongoing basis, we update it. So thank you very much for your interest, and I look forward to the questions. Thank you.
Thank you, John. I gave a challenge to Richard. Now I'll give a challenge to you. The words document, document, document sound fantastic for lawyers. We love documenting everything and writing them and being paid to write those things. If you were to put on the hat of a cybersecurity professional or a technologist, what take would you have? Would it be data, data, data? Would it be don't keep what you don't need, know what you have, know where it is? You know, what would your catch cry be from another perspective? It may still be document, 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 but I'm trying to challenge us to think from another's perspective. Richard drew us the challenge of don't just think of yourself as the defender, think of yourself as the attacker. Let's try and look at this from various perspectives and share that. One of the, when I was in-house, I worked for one of the larger IT companies, actually a US IT company, and we found that we actually didn't even know whether, sorry, I probably shouldn't say too much, but it was tricky understanding what data we had, where that data was being stored. It wasn't particularly tagged or organized in a particular way, so you don't know how long you're to retain it. Is the problem bigger than just policies and procedures, but it's the subject matter itself that we need to look at? Also, another challenge for you is to explain to us just how linked privacy and security is in the US and Canadian environment. It's certainly linked under Australian law, And do we need to somehow harmonise these laws so we're not looking in 1,000 directions for what our obligations are as organisations in this space? Now, it's time to introduce Jenna Carradil from New York, but I think you're in Barcelona at the moment. So welcome to wonderful Barcelona, where a number of our colleagues are as well. So Jenna has over 25 years experience in technology, and I have to say is one of those exceptional lawyers with degrees in information systems as well as law. And for a 25-year stint, I can only imagine the wonders that you have seen and your ability to analyze problems like, you know, as an engineer, but with a lawyer's hat on, inspirational. You've been admitted to various US state bars, including California and New York. And prior to setting up your own practice, Jenna, you were a member of an AM Law top 20 law firm and general counsel for a software company. So certainly a broad breadth of experience. Jenna represents US and international corporations on both contentious and transactional matters at the intersection of law and technology. Of course, that includes intellectual property, includes data, includes privacy. And from the privacy perspective, she's a certified information privacy professional in the United States. That's through IAPP, and a former president and director of iTech Law. Currently, I understand, Jenna, that you're on their advisory board also. So thank you for giving back to the community as well as being exceptional in your role. Jenna has been recognised by Legal 500 for her work on data protection and privacy. And I'm not familiar with these rating scales, but you're an AV. Awesome, I think A stands for, or very awesome if it was the other way around. AV rating by Martindale Hubble, and please let us know when you're off mute. And you have been recognised as a super lawyer, quotation, and apparently a registered trademark, which is quite good, for IP in New York. So as with all our speakers, it's an absolute pleasure to be for us to have you speak to us today. And we look forward to you covering the transactional side of cyber. If you can include insurance in that discussion, we'd be very grateful. Jenna, now over to you and for your presentation.
Thank you very much. Very happy to be here. So I'm talking primarily about cyber insurance. Now, full disclosure, I am not a insurance broker, so you're not going to hear about policy premiums or plugging one thing or another. But everyone else on this panel was doing some statistics, so I decided to jump on that route as well. So I did some research with some of the insurers that we use, and not to scare you, but as Richard and John may have alluded to, a cyber attack occurs every 39 seconds. Almost 600 million people were affected by cybercrime last year. There was a 400% increase in cybercrime. And that represents a 148% increase in ransomware in 2020, as well as a 600% increase in phishing. In terms of ransomware, the demands have gone up dramatically from 2019 to 2020. 2019, it was around 5 figures. We're now up to 8 figures. CNA Financial paid a $40 million ransom earlier this year. So those have gone up quite a bit. And a very sobering statistic, 60% of small businesses close within 6 months after a cyber attack. So, one of the things that we talk about is cyber insurance, and what it covers, what it doesn't cover. I'm going to take you through some of these things today, but I wanted to give you sort of a story of why it matters. And this actually happened yesterday. There was a lawsuit filed in Alabama. There was a hospital that was hit by a ransomware attack. It was hit by, they believe, or they're not saying, but other industry experts believe is one of the Russian state actor gangs. And the hospital decided not to pay the ransomware. They decided to bring up their systems independently. And so, and this is all swayed because this is obviously from the complaint, so it's the plaintiff's side. But in doing so, everything was down. including all those beautiful monitors when you walk in that beep when there are alerts, when there's heart attacks, when there's codes, all of these things going around. None of that was up. And so understandably, a lot of the senior staff had to start training the junior staff on how to do things without machines. They also didn't tell the staff apparently for a while that this was going on. And there were just little stickers on machines that they weren't working. Where this comes into play for this story is the neonatal unit. And the natal unit, the pregnant women coming in didn't have all those fancy monitors. And so they just had fetal heartbeat readouts. So the printed readouts. And so there were nurses assigned, one nurse to go look at these fetal readouts. There was a lady that came in. Apparently there was some distress in the fetal readout in the heart rhythm, and that often occurs when the umbilical cord is wrapped around the baby's neck. And that is in fact what had happened. But it was not recognized, and there's not, they haven't assigned fault on what happened, but if it had been recognized, the doctor would have come in and done a cesarean right away. That didn't happen. And so the baby was born with severe difficulties and ultimately ended up dying. And so in the US, this may be the first death, if you will, caused by ransomware. So you've got a lot of things going on here. They didn't, did they have insurance? We don't know. Would there have been coverage is something we're going to talk about, some of these policy exclusions and whether things like this would actually be covered. So with that, I'm going to go into sort of the industry. And I am speaking primarily from a US basis. The statistics I gave you were worldwide because this came from insurance companies. But generally it's referred to, at least here, as a Wild West, right? And that's, referring to how confusing it is and everybody sort of does what they want. And that really does seem to be the case with policies. You can have the same exact coverage, if you will, but because of different defined terms or lack of defined terms, you don't know what they actually mean. So, the big thing, if you want to take away something from this sort of insurance talk, is read those policies and make sure you understand absolutely and everything. And if you don't, get an endorsement, trying to negotiate so that you do understand, so that everybody understands what is and is not covered, what the limits are, and things like that. One of the other statistics that I was given was that the average paid loss for a cyber claim jumped to over 350,000 US in 2020 from about 150,000 in 2019. So these are going up. But there's really just not enough data in the industry yet. This is still an industry in infancy. So there's not really enough there to establish a reliable sense of what premium should be, how much you should buy, what coverage you should have, what shouldn't be included. So these are things that we're just going to talk about today to give you some ideas. Really quickly, this is a showing of premium raises. You'll see 2021 has gone up dramatically. Before then it was a pretty, in 2018 to 2019 almost, it was a pretty stagnant in terms of, normal raises, but it's gone up dramatically. So we're going to talk about two types of policies here. First of all, I'm going to repeat this many times. There's no standard for anything, at least in the US. There just is no standard. So cyber liability in the US is designed to give the most comprehensive coverage for cyber attacks. It's usually a standalone policy, so it's not part of your general policy. And it consists of both first party and third party coverages, which we'll talk about in a minute. It covers monetary losses from a breach and provides some legal protection. You can also see data breach policies. And that really is just going to protect your financial interest. It's only first party coverage losses for a data breach, a hack, a theft. Covers generally expenses with things like informing your customers that there was a breach, for providing credit monitoring. There are several, every state I believe has a data breach, some type of data breach law at this point, and a lot of those things are covered. Now, with that being said, because every state now has a data breach law, there is some argument that data breach these types of things would be covered under your commercial general liability. So, it may be under the errors and omissions part, it may be under commercial general liability. Again, this is all about reading and looking at what the definition of these things are. so that you can see where they fall. Data breach by itself, when you get it, generally will overcome this very small fraction of what cyber will cover. So I mentioned first party and third party. So first party really helps you to respond to data breaches on it's about your own network, right? This is including data stored on your machines or potentially data you have stored in the cloud, depending on how the definition of computer system is in your policy. Third party is issues raised against you. And so that's lawsuits caused by the data breaches. That can be things like allowing an email virus to go in and infiltrate a client's network via security hole. It can be things like using weak passwords, things that would really affect, if a client sues you. So what types of things are covered under these policies? And again, no standard. You need to read every single definition. We've talked about data breach. There's distributed denial of service, which I think pretty much everyone here should be familiar with. Where traffic is overwhelming and thus shutting down your service of your servers. Malware, we're familiar with, we've talked about. Software compromise, that can be email compromise, it can be other software, extortion, theft, for example, of IP, and extortion, demanding a payment to get it back, versus ransomware, shutting down your system and asking for a payment to turn it back on to give you access to it. So in a cyber policy, what are the typical things covered? We have notification, which I talked about. So that's sending out to your customers the, hey, you've been breached email. We've seen those. There are a bunch of companies that do that. Investigation costs. So figuring out where the breach occurred, how it occurred. Credit monitoring, that's a big one here in the US. That's generally required, that the affected customers are allowed to have credit monitoring from you. Advertising, so corrective advertising. Data breaches really affect reputations. And so potentially you could have corrective rehabilitative advertising costs there. The ransomware or extortion demand amounts themselves. And then you get into sort of those third party things, which is your litigation defense. So when you get sued, so the damage award, or if you settle a litigation. And then lastly, things like regulatory fines, because it can be fined by HIPAA, GDPR, there's all these other fines that are involved. Again, these are just typical things. They are not necessarily covered. You must read your policy. I'd like to talk and spend a few minutes really on the exclusions. So these are things that are not going to be covered. The first one is failure to maintain, and that's typically also called the negligence exclusion. And that's really the failure to implement or maintain minimum security standards, or really any security standards. Or it could be industry standards. The problem here is often this is in vague terms. What is a minimum security standard? If that's all it says, that's pretty arguable to get out of it, get out of covering you, because what is minimum? So, you can get a rider or an endorsement that lists out specifically what would meet those minimum standards. Or we've seen also where when you fill out the application to get the insurance, you say what you are doing and what your policies are, and they'll look to make sure that you are continuing to do that. And that might be set as the minimum bar. One of the things with failure to maintain too is once you understand what those standards are, have your IT look at them to make sure that you can actually do them and comply with them. We tend to negotiate some of this through lawyers, but really IT needs to be significantly involved here, because you need to make sure that it is something that you can technologically do. Ransomware extortion. So while it may cover the actual demand, the actual amount you end up paying, sidebar, there may be negotiation requirements. It may not cover you until you attempt to negotiate a certain number of times or a certain percentage down. Again, this is all in the policy. But it's not generally going to cover anything beyond the demand. Your lost income, your reputational damage, your lost clients, the IP that may have been stolen, cost to remedy the security violations. There are all these other costs that may not be included. Fines and assessments. Talked a little about GDPR, HIPAA, you can get assessments there. Those can be excluded. One of the ones that we see excluded a lot are PCI, which is the payment card industry standards. Those typically can be excluded, and they can be a lot. You know, it can range from 5,000 to 100,000 per month. You know, plus a per customer breach fine as well. There are some policies, and you can argue if you do work in that industry a lot, you can potentially get that covered. But again, it's up to you to look at your policy, see if it's there, and make sure that you get it covered. Injury and property damage. So this goes back to the story that I told you about the case that was filed in Alabama yesterday. Injury is not usually covered. So this death would not be covered. Personal injury would not be covered. Property damage. Your machine, you know, is shorted out, or, you know, has done something so the actual physical machines don't work anymore, would not generally be covered. Now, property and bodily injury damage are generally covered by your CGL policy, your commercial general liability policy. It's going to exclude cyber events. And so you have to look at whether that exclusion, you know, where this would fit in, and your cyber policy, you know, going in and excluding general events and excluding, you know, and so you're going to have to play with these to make sure there's not a loophole and that you're missing. And this comes into play, again, this is sort of US based, but we have class action attorneys, plaintiffs' attorneys. And one of the big things that they assert in these are emotional distress. That is a bodily, you know, seen as a bodily injury. Where is that going to fall? A lot of times it's not going to be defined as a bodily injury in your CGL policy, and it's not going to be covered in your cyber. And now you're going to be stuck with this potential huge sort of loophole of damages. Social engineering. I'm not going to go into all the different types, but, you know, this involves manipulating and suspecting employees to trick them to hand over money, IP, data, access to systems. Primarily, this is done by phishing emails, but it can be all sorts of things. Exclusions are generally going to apply, for example, when an employee fails to follow your documented security policies, or it happens over the phone, not a computer. And so there are exclusions here. Again, you want to try and look at and make sure the definitions of what can be covered tries to cover these things. Prior acts, you know, like all insurance policies, things you did before the effective date of that policy are not going to be covered. And this comes into play, you know, when you get a new policy, obviously there's nothing you can do, but when you switch to a new provider, you know, one of the things you should look out, like you would do with your general policy, is to try and see if there's tail coverage, because these things are often not discovered until much later. And so although it may have happened when the policy was in fact in place, you wouldn't be able to claim it if you didn't have a tail policy when you discovered it 1, 2, 3, or 4 years later. War, terrorism. This one's come up lately, and this again goes back to the Alabama hospital. It's a state actor. So a foreign government can be seen or part of that war or terrorism exclusion. There are a lot of foreign actors at this point that are doing these breaches, that are grabbing this information, that are doing the ransomware. You know, the Russian entity that hit that hospital in Alabama got, I believe, over 100 million in ransomware payments just last year. And their average demand being somewhere around $700,000. Even if they had cyber, it generally would probably be excluded unless they negotiated to cover those things. A couple of other ones that come up, just not on the list here, portable device exclusions. We don't necessarily see the devices themselves being excluded with 2020 and everybody being remote and working from home. But what we are seeing is an exclusion for not protected. So if a laptop is not encrypted, it would not be protected under this. Or if a phone is not properly secured by password, it doesn't have, you know, you can just open it right away, those types of things. Cloud services are another one. Oftentimes, if your data is on the cloud, you need to make sure that that's part of the computing system. So if you use the Google G Suite or Office 365 to house your data, you need to ensure that that is covered. Pre-breach is the last one. If you're familiar with the Kimpton case here, there was a flaw that was discovered and a litigation was filed, but there was no breach yet. And the policy was not active until there was an actual breach. It wasn't threatened breaches. It wasn't finding a security flaw. It needed an actual breach. And so they were having to cover all of this, even if they had this policy, the policy was denied. So, quickly, just to talk about policy limits, again, it's really something, people see cyber as a luxury at this point. And these are just some things to think about. We always deal in what is the worst thing that can happen. That's a lawyer's, daily life as far as I'm concerned. But how likely is it to happen? What can you afford? And look into these things. A good example is I scuba dive, right? I have dive insurance that will cover me if there's a health issue, but that doesn't mean I don't check all these other things like Richard was talking about. I'm checking my equipment, my air levels, whether whether I can breathe the air, my route, safety proof, there's all these other things. And so cyber is one of these things that we try and bring together with all the other things that John was talking about, all of these things sort of wrapping together to create sort of a blanket of trying, to try to give you protection. I was asked to talk a little bit about contracting for this, what you can do. Obviously warranty, so I'm giving a warranty, and that point, that's, going to be what is covered for how long. I can limit my exposure, right? And so if I'm only giving warranties on certain issues, I'm limiting my exposure there. For how long, is it the life of the contract? I work in telecom where we have life of contracts that are 25 years. Are you going to be doing that? Or is it for a certain period, the first 5 years of the contract? Damages limitations, the type of damages. We're going to talk about it on the next slides, but, indirect damages, loss of reputation, things like that. You can limit those. The amount of damages, are we going to put a cap on damages? Or a liability cap. We'll talk about that in a minute. And also pushing liability to third parties. Do you have, insurance is a good one to talk about because the insurers, I believe about 60% of the cyber insurers actually go for reinsurance. So most of your premium is then going to a reinsurer. And I think there's about 4 reinsurers that reinsure most of the market. So are you able to push off some liability to your vendors? Looking at indemnities and other things we're going to talk about. And I realize I'm short on time, so I'm going to talk very fast. One of the things we talk about is indemnification, defense, and hold harmless. And these terms in the US, especially the second two, are so wildly different between state. Indemnification is obviously obligating you a risk to, you're taking on a risk that you may not normally need to take on and allocating that because it seems to be fair. Given the contract that you're entering into, who should bear that burden of costs? Defense is just the defense of an action, doesn't necessarily cover costs at all. It also doesn't look at whose fault. So if you're arguing who is at fault for the breach, you're both going to have to defend. Defend is that language in there. Hold harmless is another one that can be nothing. In some states, it's the same as indemnification. But in other states, it can actually include things like consequential damages because it can include everything that happens as a result of the breach. Indemnities versus insurance. So you can't obviously have an indemnity without insurance. You can have an indemnity without insurance, right? You don't need to have insurance at all, but you can't have insurance without an indemnity that's inherently part of that insurance contract. The insurance is that contract mandating certain coverage, but they're two different things here. So you need to look at both when you're negotiating contracts, what insurance levels and what indemnity you're going to provide. And the difference here is if we say, okay, there's a liability cap, that has nothing to do with insurance. However, we often look to that cap to match the insurance if at all possible, so that so that you're not having to rely on the financial backing of that company to cover sort of whatever the difference would be. In absence of a liability cap, obviously there's no financial limit whatsoever on how much you can be responsible for a cyber event, and these can get very costly. So I think I ran through the last ones really quickly, but I wanted to leave time for questions. So my slides here.
Very nice transitioning between the slides. Okay, so how much time do we have left? We have around 15 minutes. There has a question, perhaps if I could start with you, Jenna, and Richard to jump in as well. There was a comment made around the typical exclusion of failure to maintain. You did mention standards, and from a technical perspective, perhaps there are reasons not to maintain. Maybe the patch or updating a piece of software is not recommended. Would that therefore push a corporation into a willful, intentional, or some other category because you fail to maintain, although you may have a good reason not to do so? But so standards question, maybe a more technical question around how would you ever assess whether or not you have failed to maintain when there are typically many other balls that you're juggling at the same time? Any ideas or comments on that? That'll be great, please, Jenna and Richard.
I was going to say, I was going to let John answer because I think from the technical
John,
he can give you some of that, but from the insurance side, it's really what the language of the contract is, right? And so you really need to understand what isn't covered. If you put in there that you are going to do all updates and maintain the software appropriately, and you don't, that's a breach of that, and that's going to be excluded. It doesn't matter if you have a good reason necessarily, because you contracted to do something and you have not in fact done it. Now you could look to other areas of the contract that may, give you some leverage in terms of, well, it wouldn't have, worked here for this reason, and this is, gave us better protection. But you're going to be arguing at that point, you're still going to be defending that action and paying for it while you also argue with the insurance.
The only thing I would add to that, I think that was very good, is there are sometimes very good reasons why an organization will not update to what's the most current system. It might be that implementing the update could be very disruptive for the company. So maybe they're going through maybe they're rolling out a new system or implementing a new system. I think at a certain point, if you're so many updates behind, I think you're really going to expose yourself. I think Jenna is absolutely right in terms of what the language says in the insurance policy. I think if you're 2 or 3 updates behind, I think there'd be a bit of a raised eyebrow as to whether you're staying current. But I think it's completely normal to not be at N-1 with respect to your updates, because it comes with a cost. It can be highly disruptive. You might need new training, et cetera, et cetera, et cetera. So it's a great question because it's very nuanced and it's going to really depend on the context. So
I did want to jump in, and because it has happened to me a million times, which is, for example, my Microsoft Windows updates, and it kills something, right? But I've done the update and now all of a sudden something doesn't work and I've rolled back. So I'm not technically updated. And so again, I would look to the insurance contract and make sure that you negotiate language that would account for that. If that's something that frequently occurs, any type of software that you have that you maybe want to wait, until a version is completely rolled out, or this, the iteration of it, to make sure it's not going to affect your company, or you only update internal systems and not the live systems or something. But this is all about negotiation. And trying to make sure that it fits the right, what your company does.
I wanted to make one very quick comment on the dynamic between vendors and customers, because for a lot of customers, and I act for both, so I have sympathy for both sides. A lot of times you'll have a customer that'll basically effectively try and impose a strict liability regime on the vendor. They will say, you have our data. If there's any data breach, I don't care if you have the bleeding edge security technology, but if you get hacked by a super virus, you're responsible because effectively you have our data, you should be responsible. And from a vendor's perspective, that seems completely unfair, right? Because it's the old dynamic of the vendor saying, why would I be your insurer? Like, if you're not spending $100 million in security in your company, now you want us to spend $100 million on security measures. So I think that can be a real tension between a customer and a service provider in terms of, and I think the best way to do it, my own view, is if you can settle on a security schedule whereby you have an agreed set of security requirements that the vendor is intended to do. If the vendor does all those things and there's still a security breach, they shouldn't be held to being fully responsible for that, because they did what they're contractually obligated to do. And as I said, a lot of customers, because it's easy and convenient, will effectively try and impose instead a strict liability regime whereby if there's a data breach, you're responsible, full stop.
I have a slightly different take. I can think of no circumstances under which it would be acceptable not to apply a patch. So I think we should probably separate feature upgrades, which might break things, and security patches, which might break things. Feature upgrades, absolutely. And it's, I would actually have a problem with my vendors mixing the two together. But security upgrades, you have to patch them straight away. I've been involved in 2 breaches recently where it took 3 days for someone to apply a patch. In that time, they were compromised. As soon as a patch is released, the patch is essentially a how to hack this system to the whole world. So from the minute it's released, you can assume 3 minutes later, all the bad guys know about it. And they're now starting to scan, finding out who hasn't patched. So in the old days, you could allow a window of a day or 2. I think it's unconscionable now not to patch instantly for security. But for features, absolutely, of course you do. And if it means you break things to upgrade, then you have a real dilemma. and that's something that needs a lot of thinking. But to not upgrade to solve that dilemma, to not patch the security problem, it's like saying, yeah, the airplane, we've just discovered a flaw in the engine and it might explode. Yeah, we'll wait for 3 months and then we'll fix it. Yeah, do I have to ground my planes? Does that cost us lots of money? Who's going to pay for that? I don't know. But anyway, slightly different take.
It's a question of standards. How do we know what standard to apply? As an engineer, how do you know if you're up to scratch or if you're at the most reasonable or industry accepted or level?
Well, I think Jenna answered that. I think Jenna answered that well already, and John did too, which is there's what the contract says, and then there's what you should sort of morally do. And probably for the intents and purposes of insurance, it's what the contract says, and presumably that specifies the standard. In terms of what you should morally do, that's quite difficult because there are many standards. And as I was trying to say before, put together, they're still insufficient. So you can follow every single standard under the sun and you're still vulnerable. So now it becomes a trade-off question. Yeah, it's very difficult. And there's lots of contention over this, and there's lots of competing standards. And there's too many to follow them all unless you've got a huge budget and can employ a huge governance, risk and compliance team. Very, very costly. So that's a difficult decision, Marina.
I also think you have to look at what industry, right? Because certain industries may not be doing things correctly. So the industry standard may not actually be sufficient to meet your insurance obligations.
Yes, yes. Brilliant point.
I really don't want to finish this session saying, oh, it's not hard. So let's talk solutions in the time that we have available. I think there's around 6 minutes left and we have 3 speakers, 10 minutes each. Please tell us what we can expect in the future and maybe even just what critical conversations do we need to have at IFCLA to address these issues. John, would you like to go first, then Jenna, and maybe we can end on Richard in the time that we have available. John, you're on mute.
I apologize. You faded out a bit during your question. Can you please restate the question?
It could be on account of it being early in the morning, but here we go.
Fair enough.
I really just don't want to leave this session with the impression that it's all too hard. We just try and do our best and hope for the best. So maybe some forward-looking analysis or where you see things developing, and perhaps what critical conversations should we be having at IFCLA and with our clients to help steer us in the right direction.
I think it's an interesting question. Lawyers are increasingly required now to be experts, and we always have been, but perhaps even more now, in areas where we're not naturally trained to do it. I think that lawyers could well benefit from understanding a couple of things better. I think it's impossible to be a good lawyer in this space without understanding insurance, because there's no point in negotiating your brains out and indirect damages disclaimers and limitation liability clauses, et cetera, if you don't understand the insurance context behind that for your client. So, and insurance can be turgid, but I think it's critically important. I would make the same observation in the security space with respect to understanding different standards. So what's the difference between the, ISO, this particular ISO standard or this particular security standard, et cetera, et cetera. And I will guarantee you that the majority of lawyers do not understand those standards. They may draft for them, they may put them in contracts, but if you ask them what the actual requirements were, they would not know. And given how important security is right now and how we can have deals fail because of a disagreement on liability for privacy/security breaches, I think it's critically important that we as a group of practitioners better understand what those security standards are, because as the observation was made earlier, absent having detailed requirements set out in the law, we have to look at those standards, and that means we have to understand what those standards say.
Very good. Thank you. Jenna, your thoughts, please.
Sure. I mean, I think mine is an easy one. He says, you know, be a programmer, I used to work in this space, and it involves the people that are actually doing this day-to-day. Involve IT, involve security, involve, you know, the people that actually are seeing these things on the ground, you know, are watching the network, or seeing what type of intrusions there are, you know, are going around, you know, testing your security, pen testing, all these different types of things, you know, that are talked about. I just think you can't be a good lawyer in this space without really involving that. And I think part of that too is staying up to date on trends. You know, we jumped in ransomware this year, in particular types of ransomware, and those trends change every year. You know, the technology is ever evolving. You know, like Richard said, you're not, you know, nothing is 100% safe. So there's always going to be some openings there, and it's trying to keep up to pace with the technology and where those are.
Thanks, Marina. I think John gave a really nice summary in his survey of the 4 most important things to think about and to encourage your clients to think about. And they were training, and probably training at the top of the list, training for everyone from CEO down to frontline staff, having a response plan. So don't having it the first time you think about a problem is when it's happening. Have a decent plan, well worked out, and train on it and rehearse on it, like fire evacuation. Delete. So any data you've got, assume you will be compromised, because you will. Practice writing the disclosure letter that you would have to write to inform everyone that you've lost their data. I find that is a really nice way of persuading to the board that maybe all that lovely data we're holding on to, because it might be useful one day, is toxic, like nuclear waste, and we should get rid of it. Because if you've got it, someone will find it, and if you're holding it, you're responsible. And then the last of the 4 would be test. So constantly test. Desktop test, sure, but get external parties to come in and test. You can never test yourself, of course. You're thinking like a defender. Oh, look, everything's really good. So just constantly test all the time. Jenna said, stay up to date. I think that's spot on. You said, is it despairing and depressing? I think it is certainly the case you will never be secure, but you shouldn't despair. You should do the best you can. Like that REM song, Everybody Hurts. Just hold on, do the best you can. And anyone that tells you you can be secure, now you know you've got a test to working out if someone's a charlatan. If a security firm or someone comes up to you and makes some sort of promise, stay away from them. They're no good. They're my tips for the future, Marina.
I think we're right on time, and Glenn will be joining us shortly. So just a few wrap-up comments from me. Thank you again to our wonderful panel for joining this discussion. The conference has been a wonderful success. We're very fortunate to have played a part. Cybersecurity, of course, affects everything. It affects blockchain, it affects EU regulation, it affects digital supply chain, it certainly affects privacy, data protection. The list can go on. It affects digital currency, smart cities. The list is very long. It calls for greater cooperation, certainly multidisciplinary engagement. And today we were very fortunate to have a professor of cybersecurity join the panel with lawyers and experts in insurance through to privacy. We're confident that through organisations such as IFCLA, that those essential conversations will continue. So thank you again, IFCLA, for having this session. And thank you again to our wonderful panelists. Now, Glenn, I think you'll be joining us on the stage, and there you are, and you're speaking on the phone. See, you had to update your software on that phone, and you did it straight away on Richard's advice. We love that, Glenn, and we love your work as well. Thank you for joining us, and I think we're signing off now for the panel. All the best, everybody. Thank you for joining us.
Thank you all.